The fight over the future of suppressors and short-barreled rifles just reached a historic moment. A federal court in Texas has officially ruled that key portions of the National Firearms Act can no longer be enforced against suppressors, SBRs, SBSs, and other untaxed NFA items because Congress eliminated the underlying tax that originally justified those regulations. This is one of the biggest legal blows that's ever been delivered to the NFA, so let's break down exactly what the court did, why this matters, what happens now going forward, and answer some big questions that a lot of you guys had from my last video. Now, before we jump into this video, if you like this type of content and you want to make sure you get it going forward, make sure to subscribe to the channel and also turn on all notifications to never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, they're a league of their own. They also just added in a new benefit for all members. If you sign up using my links down below in the details section or the pinned comment and you use my code ARMSCHOLAR, you become a member, and now as a member, you will get free online trading education with their new partner, Achilles Heel Tactical, who are good buddies of mine. I actually helped to onboard them with AOR. I stand by their training. I've learned a ton from Achilles Heel Tactical, Rick Crawley, and the team over there. And also, if you sign up as a member, you will get exclusive discount codes to go train with Achilles Heel Tactical in person. So if you're interested in something like that, check them out using the links down below. So if you've been following the channel, you will know that this litigation here started after Congress passed the One Big Beautiful Bill. That legislation reduced the NFA making and transfer taxes on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons from $200 all the way down to $0. That immediately created a constitutional problem, especially for the federal government. Historically, the NFA survived constitutional scrutiny because the Supreme Court viewed it as an exercise of Congress's taxing powers. The argument was relatively simple. Congress imposed taxes on certain firearms and created a regulatory framework to help administer and enforce those taxes. But what happens when the tax is now eliminated? Can the government continue requiring registration, fingerprints, background checks, approvals, and also put in place felony penalties when the underlying tax has now been done away with and it's $0? That question became the focus of the Silencer Shop and Jensen consolidated cases that went in front of Judge Hendricks in the Northern District of Texas in a federal court. Now, this week, in a lengthy opinion, Judge Hendricks concluded that the NFA's registration and enforcement provisions for suppressors, SBRs, SBSs, and AOWs can no longer be justified under Congress's taxing powers. The court's reasoning was very straightforward. A tax that raises no revenue is not functioning as a tax. Once Congress reduced these taxes to $0, the constitutional foundation supporting those regulatory requirements has now disappeared. The court rejected the government's argument that the regulations could still be justified through other tax-related theories under the NFA. The court also rejected the government's fallback argument that the Commerce Clause could save these provisions. And so that's also very significant, and it's a critical part of this decision where the court was not willing to extend the fallback Commerce Clause argument to the federal government. The DOJ essentially argued that even if the taxing clause rationale no longer worked, Congress still possesses authority under the Commerce Clause, but again, Judge Hendricks denied that type of analysis, and he was simply not persuaded. He concluded that Congress enacted these provisions under its taxing authority, and the courts cannot simply rewrite the statutory foundation after the fact. As a result, the court granted summary judgment in favor of the named plaintiffs and issued a permanent injunction preventing enforcement of the challenge provisions against the covered plaintiffs, their members, and their customers. However, I do need to note, and this is critical, so pay attention, essentially he put a 7-day stay on the enforcement of his ruling. So he put kind of this administrative stay on it on his own for 7 days, and that's going to remain in place to see essentially what the federal government, what the DOJ wants to do. So essentially he has given the federal government until next week, August 12th, to appeal that ruling to the 5th Circuit and get an additional emergency stay from the 5th Circuit. Because of that, we are currently in this 7-day holding period, waiting to see, how does the Trump DOJ respond? But as we're in this waiting period, as it stands right now, the NFA is still operating as it traditionally did, just with a $0 tax. So now let's talk about what this injunction actually does. The court barred enforcement of major provisions of the NFA's registration and approval requirements against the named plaintiffs, their organizations, their memberships, their members, and also their customers. That includes the registration and transfer framework that normally applies to suppressors, SBRs, SBSs, and AOWs, and other untaxed items now. However, this is an important limitation. Essentially, this is not a nationwide injunction. The Supreme Court's recent rulings has significantly limited the ability of these lower courts to issue universal nationwide injunctions. So the relief here in this case is tied to just the named parties like GOA and these 2A organizations and their members. So, with that in mind, with this case and this recent ruling, I highly recommend that you become members of some of these organizations. One of my favorite ones is GOA. I will leave a link to them down below. And, if you're a member of GOA, you would also be covered by this ruling. So again, check that out in the pinned comments in the detail section. Now let's talk about some of the major questions that popped up after my last video. A lot of you are asking, well, what happens now going forward? And the answer is really just an appeals process. And probably very quickly, there is going to be an appeal in this case because, again, that 7-day stay is only running until next week on Wednesday. I fully expect the DOJ and the ATF to file an emergency appeal. They've shown that that is their track record, especially recently when it comes to the NFA. Of course, I would love for them to not seek an emergency stay or for them to simply appeal this case, but again, not seek a stay and just let this stand. However, I would be shocked if they actually did that. I think that they're going to appeal this and also seek a stay from the Fifth Circuit. So that means that the first major battle really is likely going to come down to this Fifth Circuit appeal and the request for an emergency stay. Of course, the Fifth Circuit motions panel could deny that request for an emergency stay, so there's going to be some briefings going back and forth, about that issue. So that is something we're going to have to also watch going forward. If the Fifth Circuit grants a stay pending appeal, the status quo remains in place while the appeal proceeds. If the Fifth Circuit denies a stay, well, then the injunction could potentially take effect for the covered plaintiffs while the appeal also moves forward in the Fifth Circuit. After that, the normal appellate process begins. You have briefings, oral arguments, the Fifth Circuit decision, and eventually this is one of those cases that no doubt will make its way to the en banc panel in the Fifth Circuit and probably also eventually the Supreme Court. Now, the second major question everyone keeps asking is, does this eliminate state suppressor and SBR bans? Now, the answer to that is simply no, not directly. This case only challenges federal NFA regulations using the $0 tax as a basis. The state bans are completely separate laws. You have state-specific laws in states like New York, New Jersey, and California. Those laws do not automatically disappear because of this ruling. However, that does not mean that this ruling here is irrelevant for those cases in litigation that's currently going on. In fact, it may become extremely important. For decades, these states have been defending their suppressor bans and their SBR bans, and they've pointed to the NFA as evidence itself that suppressors and SBR somehow are dangerous and unusual items, and that's why they're regulated by the NFA, and that's why the states can put in place these types of bans. But Judge Hendrick's opinion here undercuts that narrative, especially if the stay is lifted and ownership of suppressors and SBRs grows and goes through the roof. That strengthens a lot of these arguments that these are not dangerous and unusual items. In fact, they probably are going to grow in common use. So when you zoom out, this is why this moment is so significant. We now have federal litigation challenging the NFA, state litigation challenging suppressor and SBR state bans, government admissions in other cases that suppressors receive 2A protections, that suppressors are protected arms, and courts increasingly being forced to confront the constitutional status of these items directly, especially in light of the new NFA $0 tax on these items. And really, over the next week and these next months, this could become one of the most important kind of periods when it comes to NFA litigation and what the status of the NFA is going to look like going forward. So that's where things currently stand right now. Judge Hendricks has ruled in favor of the plaintiffs. The DOJ is likely taking this case to the Fifth Circuit, and the fight over the NFA is going to enter this appellate process, and we're going to have to wait to see what the Fifth Circuit does with potentially a request for an emergency stay, and that will really determine if this new ruling goes into effect or if it's going to stay essentially stayed for the period of the appeal. So let me know your thoughts and comments down below. If you have any specific questions on how this is going to operate or about the ruling itself, let me know down in the comments section. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.